Hello, this is Professor Weissman's PowerPoint presentation designed to teach the remainder of the Criminal Justice Process course remotely. It can be accessed on Blackboard and on YouTube at Professor Weissman's CJ Courses channel. This is Unit 5, and we will cover the right to confront witnesses. In Unit 5, we will be looking at the Confrontation Clause of the Sixth Amendment to the U.S. Constitution. In particular, we will explore the history of the Confrontation Clause, how the clause is actually used and applied at a trial, and exceptions to it. The Sixth Amendment to the United States Constitution provides that a person accused of a crime has the right to confront a witness against them in a criminal action. This includes the right to be present at the trial, as well as the right to cross-examine the prosecution's witnesses. The Confrontation Clause was created basically to prevent the prosecution from using a written document, such as an affidavit from a person, without that person actually testifying at the trial itself, and to give the defendant an opportunity to face his or her accusers so that the jury can assess their demeanor and credibility. This is a constitutional right. The history of the Confrontation Clause, as does much American law for that matter, can trace its origin to English law. For example, it was a common practice in English courts in the 17th and early 18th centuries for written statements made by people outside of the courtroom to be used as evidence at a defendant's criminal trial. Although defendants would ask the presiding judge to order the person who signed the written statement to be brought to the courtroom, such requests were usually not granted. In other words, someone could be convicted and even executed for a crime based on an out-of-court statement made by a person not subject to cross-examination. The founding fathers of the Constitution placed the Confrontation Clause within the Sixth Amendment in the Bill of Rights as a direct reaction to the former practice of the King's use of these out-of-court statements against people at trial during colonial times. More than 125 years ago, in Maddox versus the United States, the U.S. Supreme Court set forth the three fundamental purposes supporting the Confrontation Clause found in the Sixth Amendment. 1. To ensure that witnesses would testify under oath and understand the serious nature of the trial process. 2. To allow the accused to cross-examine witnesses who testify against him or her. And 3. To allow jurors to assess the credibility of a witness by observing that witnesses' behavior as they testify at the trial. Confrontation of witnesses at trial is a fundamental right applicable to all states. Bear in mind that once the Supreme Court declares that a right is fundamental, the states can make no law going below that standard, although they are free to give individuals greater rights. Where an action is deemed not to be part of or constitute a critical proceeding in a criminal prosecution, then there is no right to confront witnesses. So, for example, a defendant has no right of confrontation during a pretrial hearing to determine the competency of a child witness, as it is deemed a non-critical proceeding. Under the Confrontation Clause, the courts have determined that a defendant has a right to several things, which will be discussed in the next several slides. These include to be present at trial, the clothing worn at trial, the identities of witnesses who may testify at trial, and the right to have a face-to-face confrontation with those witnesses. A defendant has the right to be present at his or her trial unless that right is waived. The waiver of the right to be at one's own trial must be found by the court to have not been a product of deliberate absence on the part of the defendant, or that the defendant created some kind of disruption. However, with disruption, the defendant is usually allowed to return if they promise to behave. So in disruption cases, before removing a defendant altogether, a judge can hold that person in contempt of court, which would then force the person to either pay a fine and or be incarcerated for the contempt violation, or the judge can order the person to be bound and or gagged in front of the jury. Because of the confrontation right, a judge cannot force a defendant to wear prison clothes while in court. Because of the Confrontation Clause, a defendant has the right to be informed of the identities of any and all prosecution witnesses, so that any such witnesses must reveal their true identities, except in those cases in which anonymity or pseudonyms are used to protect the witness from harm, such as from gang retaliation or threats. Because of the Confrontation Clause, a defendant has the right to a face-to-face encounter with witnesses at trial, except when preventing face-to-face confrontation serves an important public purpose and the reliability of a witness's testimony is otherwise assured. We will talk about this in the next slide. In Maryland versus Craig, the defendant was charged with, among other things, child abuse, first and second degree sexual offenses, perverted sexual practice, assault, and battery. The victim was a 6-year-old girl who attended a kindergarten center operated by the defendant. To protect the child from potential further trauma from having to see her attacker, she was permitted to testify by one-way closed-circuit television at the trial. Note here, this is not a pretrial procedure, which may not be critical, but the actual trial itself. Once the procedure was invoked, the child witness herself, the prosecutor, and the defense counsel would withdraw to a separate room. The judge, jury, and the defendant would remain in the courtroom. The child witness is then examined and cross-examined in the separate room, while a video monitor records and displays the witness's testimony to those in the courtroom. During this time, the witness cannot see the defendant. The defendant remains in electronic communication with his or her defense counsel, and objections may be made and ruled on as if the witness were testifying in the courtroom. This procedure, as I just described, was the one that was approved by the Supreme Court. In Coy versus Iowa, the defendant sought review from the Supreme Court when the state court upheld his conviction for 2 counts of lascivious acts with a child after a jury trial in which a screen placed between the defendant and the 2 complaining witnesses blocked him from their sight. The Supreme Court reversed the conviction, finding that the screen was specifically designed to enable the complaining witnesses to avoid viewing defendant as they gave their testimony. The court held that it was difficult to imagine a more obvious or damaging violation of the defendant's right to a face-to-face encounter and struck down this method. In this slide, we discuss the Bruton Rule. Generally, under the rule, confessions of a co-defendant cannot be used at a joint trial when a confession incriminates the other defendant. So, for example, if A and B are tried together, if A confessed, that confession cannot be introduced at trial against B. However, in a conspiracy trial, the Bruton rule does not apply, and statements made by one defendant in furtherance of their conspiracy can be used against all of the defendants, even at the same trial.